I see everyone is still joining. Good morning. Morning to everyone that joined. I'm just going to allow for a few more minutes. I'm cautious of the time. We have a jam-packed program. I'm going to allow for one extra minute. I think let's kick it off. Good morning, everyone. Welcome to Friday. Friday is my day because I can interact with the customers on very relevant topics. In today's webinar, we are going to cover how to prepare for an FIC audit. Our compliance specialist, Cedric Afendi, is going to give us a step approach on the readiness for your organization for an FIC audit. The Financial Action Task Force conference in June this year expressed their satisfaction on the or the efforts that South Africa has put in place on the progress they've made for the grey listing process. Now, South Africa's got two reporting cycles left, one in September and another one in January 2025. As per the next reporting cycle, South Africa is required to address at least 9 of the 14 outstanding items as per the action plan. In a media release on the 2nd of July, Treasury remarked that they do not foresee South Africa exiting the grey list before June 2025. As an accountable institution under the Financial Intelligence Center Act, it's crucial for companies to maintain compliance with anti-money laundering and terrorist financing regulations. After this webinar, you will have a solid and comprehensive understanding of what steps needs to be in place for your organization to be audit ready and to show your commitment in combating anti-money laundering and terrorist financing. I don't want to spend too much time on all the details. Just a few requests as part of the session today. Yes, the recording of the webinar will be shared with the delegates who attended this session. I would like to invite you to the LexisNexis YouTube channel, where you can access previous webinars, subscribe, and also access some of the other informative webinars we've hosted over the years. There will be polls that come up through the course of this session as well, and I would like to invite you to participate in these polls. And these insights is crucial for us as we want to action it accordingly. Also, if there's any questions and we get to the Q&A session that you'd like us to address, I've got colleagues that are manning the Q&A. Please add them to the Q&A part at the bottom of your little tab for the Q&A session. We would like to address as much as we can on the time. Cedric is the subject matter expert from Masthead. He will do the bulk of the session, whereafter Vinette will showcase the solutions LexisNexis has to offer to actually help you in this compliance process and policies and procedures that you need to have in place. Without further ado, Cedric, good morning and welcome.
Morning. Thank you very much. Welcome, everybody. Truly great having you all here so early on a Friday morning. And I'm sure all of you are very excited to hear about what it is that I'm going to talk to you about today. So I hope that when leaving today's session, that you'll have a little bit more of a clear understanding when it comes to what does it actually entail to be FIC compliant. There's a lot of aspects, there's a lot of moving mechanisms, and I think there's still a lot of confusion out there on what is it that when I'm called on by a supervisory body or the FIC itself, what is it that they will be looking at. So before we get going, just a little bit of a background around Masted. We opened our doors in 2020, sorry, I beg your pardon, in 2004. This year, October, actually marks our 20th existence, our birthday. And from the get-go, we specialize in the financial services industry when it comes to phase legislation, and then, of course, FIC legislation as well. Calling on our customers and calling on our clients and making sure that they are compliant, and not just compliant, but also helping implement practical solutions to becoming compliant. And then, of course, in 2016, 2017, we had the rollout of the brand new FIC Act. And then, of course, we embarked in a journey in creating a comprehensive offering relating to helping accountable institutions, not just in the financial services industry space, but around all sectors. We spent a lot of time, spoke to a lot of experts, and in my opinion, built a very solid offering with assisting accountable institutions to understand this piece of legislation, which is so much more complicated now than it's ever been before, in order to navigate themselves so that they can get to a position where they feel comfortable and that they understand why they do what they do. I think that is the most important part. Why do I do what I do? Why do I need to comply with this piece of legislation? I have got very limited time. I'm going to share a lot of information, as much as I possibly can. I'm sure you're going to have a lot of questions, maybe not today, but as you go through your weekend or next week, I encourage you to reach out to us if there's any questions that you need to bring some clarity going forward. So why this specific webinar? Why how to prepare for FIC inspection? Why not just give FIC training, which we do, by the way, as well? Over the years, we've been part of several FIC audits, whether it's by the supervisory body or FIC itself. So we've gathered all these experiences that we've had, the information that was shared, sitting through these audits, and decided to put something together that is practical for people to understand. As an organization, we have people phoning us saying, I'm getting a FIC audit. Can you please help me? And yes, of course, we want to help. It's our heart and our passion to help you. But when you start asking these questions about how compliance ready you are for your FIC audit, you tend to find that, unfortunately, there's a very big misconception of what actually needs to be in place. What will the supervisory body or the FIC actually look at? And then sometimes, sadly, we've got people that phone saying, on a Thursday, I'm getting a FIC audit on a Monday. Can you please help? And at that moment in time, I cannot help due to the time constraints, because this is not something that happens overnight. This is an ongoing journey. This is not a piece of legislation as before 2016, where I have a document, I put it somewhere, nobody knows where it is. We know apparently I need to get a copy of an ID and proof of address, and that's what FIC was to me. This needs to be a living, breathing procedure in your organization on a day-to-day basis. This needs to form part of what it is that you do. This is a very, very important part of regulation. It's complex, not always easy to navigate, and nothing wrong with reaching out and asking for assistance. There's two aspects for me to this. One, yes, we need to comply with regulation because it's required to do so. not just by the FIC, but because South Africa is part of the Financial Action Task Force, where we take our guidance from, we need to make sure that we comply with those 40 recommendations and those 9 special recommendations. That's extremely important. But to me, a little bit more than that is, if you go and unpack this legislation, if you really spend time and you read through it, this should not be a burden, which I understand sometimes it can feel because of the amount of time and effort and stuff that you need to do. But if you really go and look at this piece of legislation, it's created and written and put forth in such a way where it's going to protect your organization or your company from people that want to use it to do unlawful activities. So if you want a little bit of a mind switch, and if you want a little bit of a tip, yes, you need to comply, but do the necessary to protect the organization that you work for. Those of you that have built up your own organizations with a lot of blood, sweat, and tears and money wants to protect your assets that you've built. So by doing these things, following the guidelines, looking at the legislation, you are putting yourself in a position where you can reasonably, as far as possible, protect your organization from somebody that wants to use it, whether it's to launder money, whether it's to fund terrorists. And I beg of you, please do not think that it will not happen to you. I've unfortunately seen cases where people say to me, that's normally the first thing that I hear. I need to implement this. I need to do this. All my clients are low risk. That might be the case, but you're going to have to show me why you say that everything in your business is low risk. And what did you put in place, and how did you determine, and what factors did you take into account to do so? Because these people out there, the same as you are specialists in your field, the same they are specialists in what it is that they do. And that is, unfortunately, the sad part. So please enjoy the morning with us, and try and take as much as you can. I cannot go into all of these aspects in depth. Some of these aspects that I'm going to mention today is an hour-long session on its own. So this is a high-level view of what it is to expect. But at the same time, going back and checking to see, am I doing what I am supposed to be doing to become compliant? So hopefully this session is going to benefit in 2 ways. Give you a little bit of idea what to expect when it comes to an audit. And then secondly, making sure that I'm ticking all the boxes. Okay. So as mentioned, my name is Cedric Baiki Effendi. I'm from Marsted, the area manager for the Western Cape, and also the senior business development advisor. So big part of my job is taking legislation in collaboration with my colleagues, unpacking them, going into somebody's business, looking at their business, understanding their business, and then practically implement this piece of legislation so that it speaks to your business. So let's start off with our agenda for today is, why must you comply with the FIC Act? We'll look at that quickly. We'll look at before the inspection, during the inspection, and then of course after the inspection. Okay. So why must you comply with the FIC Act? Number one, if we look at the possibility of getting an audit, whether it's from a supervisory body, and I'll unpack that a little bit later, or the FIC itself, there's very, very strict protocols that these people follow, whether it's an analyst or an inspector. They don't just rock up at your door, okay? They need to follow certain steps, all right? That generally is seen as what we refer to as a friendly inspection. So it's them calling up on you just to check and see how compliance with the regulation is within your organization. But that's not the only time that they'll pitch up. There might be grounds where they suspect very, very serious misconduct. And that, of course, will be a completely different approach. We're not going to delve into that at all. That's up to the supervisory body or the FIC after they've done certain investigations. So it's not always to say it's friendly, but hopefully everybody here is not part of anything where there's serious misconduct. But that type of, as I say, scenarios are dealt with completely. Okay. Also, not all the audits will cover the same content. It might be that whether the supervisory body or the FIC are following a theme for a quarter, where they specifically might only focus on screening. How does your screening look? What do you screen? Are you following what is required when it comes to screening? Is it automated? Do you use our web? All of these type of things, and they'll go into detail relating to screening and also how often you screen. Okay, might be that the inspection is also focused on your risk management compliance program, your RMCP, and that of course is up to them, whatever it is that their theme is for what they want to focus on within the specific organization. What we're going to look at today is a little bit more of a holistic approach relating to checking basically everything within your organization. So that's what we will be focusing on today, so that you can also sit there and tick and saying, yes, I am doing what I'm supposed to be doing. I feel comfortable with what it is that we are doing, and that we are complying with all the relevant regulation at the end of the day. So why should I comply with the FIC Act? Since 2016, 2017, we've seen various changes. We were introduced to certain timeframes that we needed to stick to since 2017. I can't delve into all of them, I'm not going to mention all of them. And as and when certain things came into effect, whether it was screening, whatever the case might be, we had some more changes that came in around about 2020. And 2020's changes entailed that there will be a lot more accountable institutions than as before. For an example, high-end value goods dealers, crypto assets, payment clearing services, all of these type of things. So there's been a lot of changes. And I'll quickly make a little bit of a mention. Hot off the press on the 8th of August, the FIC also released their PCC 59, where they are making certain recommendations which they want accountable institutions to follow. So throughout this journey, staying on top of these things, because way back in 2017, you might have implemented, for an example, a risk management compliance program. But since then, there's been a lot of changes, and that document needed to adapt. Processes needed to adapt. Training need to be revisited. So it's very, very important that one stays up to date with the changes as and when it comes. And the longer we are on the gray list, the more changes will probably happen. So as a collective, as accountable institutions, the only way that we can get off this gray list, which I think is an imperative thing for us to do for the country, is that we work together. We work together in order to do so. Okay. That's the only way we're going to get that done. Everybody needs to play their small part so that we can get to a position where the Financial Action Task Force feels comfortable with taking us off the actual grey list. Right. So let's just quickly have a look at who might come and visit you, depending on what industry you are in. So there's been some changes there as well that came into effect. So if we look to the left, institutions, financial services providers, they might be visited by the FIC, or also the FSCA, which is the supervisory body for the financial services industry. Legal practitioners, you will be visited by the FIC itself, the Financial Intelligence Center Act. Credit providers, exactly the same. Banks, the Prudential Authority, and then, of course, gambling institutions, the Financial Intelligence Center Act, FIC itself again. This is just a summary that we've put together due to the fact that the slides will be sent to you just to make it a little bit easier. There you can see under the different items, where there's a supervisory body involved, or if FIC is the only body that will be calling on you from an audit perspective. So the last bottom part, legal practitioners, trust company service providers, estate agents, gambling institutions, credit providers, post banks, high value and good dealers, so forth. The FIC supervises and enforces compliance with the FIC Act. So if you're in those type of industries, you will be called on by the FIC itself. Some of the other accountable institutions will also be called on by a supervisory body. Type of inspections that you can possibly get. Now, just to quickly make mention here, because I already know that you're thinking on-site, off-site, and that you think the one's more serious than the other. That's not the case, okay? As you all know, the whole world went through a pandemic not so long ago, but the FIC couldn't stop because the aim at that moment in time, what they were fighting for, was not to go onto the grey list. So that's where off-site inspections came in, okay? Virtual off-site inspections. The one is not more serious or more intense than the other. It's just the way of how they do it. And because of the success, because when you do off-site inspections, you can get to a lot more accountable institutions in order to do audits. Because if we look to the left and we look at on-site and look at some of the things that happen there, obtain information from the institution during the inspection. We'll talk about that a little bit later. There's standard inspection questionnaires to be completed during the inspection at the premises of the institution. It's a full scope inspection. They look at a lot of things. At least 2 inspectors at the inspection. They will obtain physical inspection documents. A little bit of a slower turnaround when it comes to the completion of the inspection. When, giving you your feedback, they will do client sampling. They'll complete at bank statement reviews. And then, of course, also communicating with relevant staff and speaking to relevant people. The offsite inspection, a little bit more different, still the same focus, but of course, a lot of these things will be done electronically. So the meeting and the discussions will be virtual. They are still going to ask for file sampling that needs to be sent through to them, the risk management compliance program that needs to be sent through to them, FICA training records, whatever it might be. The thing with this is there's no travel required, so they can do a lot. They can do a lot more. There's also something which has been happening over the last couple of years, which they refer to as a desktop audit. And the desktop audit is basically mainly focused on the actual risk management compliance program, very similar to the directive that you've completed or hopefully completed. So you get a set of questions that you need to ask. You need to send your RMCP to them. They then go through the questions that you've answered. They look at your RMCP. They look that it speaks to one another. They will do some file sampling. And then, of course, they will report back to you. So there's different ways of going it. So as the legislation evolved, so did the way approaching audits evolved. We needed to do that. They needed to do that so they can get to more people to do so. Right. So who's going to check up on me? How is this actually going to work? So first of all, whether we talk about an analyst from a supervisory body or an inspector from the FIC, there will be an appointment letter advising on the request, the date of the visit. The letter is sent, of course, in advance to you. The analyst will request certain information and documents to assist with preparation for the visit. And that in general is for them to get an understanding of what it is that your organization does, so that they can prepare their side with relevant questions that they want to answer. It is necessary for all key persons to make themselves available on the dates of the audit. Very important. Okay. The responsibility of complying with this legislation does not just lie with one individual. It clearly talks about the people that govern the organization. Okay? So you need to make yourself available for those specific dates. And then, of course, interviews. I know that the slide says that, they might interview specific individuals, talking to them. And of course, the reason for that is, we'll talk about that as well. In my experience, the majority of audits that I've been involved is that interviews were conducted. And the main reason for that is they want to know and see, is this a living process in your organization? Does your staff know what is documented in their RMCP? Do they know the processes? That's the only way for them to be able to identify, to see, is this just a document that you created, put in a cupboard, and yes, we try and follow it to the best of our ability, or have we made this part of our day-to-day activities? Right. So before the inspection, what happens there is, to give you some tips, be prepared for the inspection. And in that alone, there's a lot of information that lies there. Know what is coming your way. They will be clear in their letter, but be prepared. Be prepared for the inspection. Know how to answer certain questions. Make sure that the people that you engage with, that they understand that you take this piece of legislation very, very clearly. And that it's an easy way to talk. This is not something to shy away from. This is something to embrace. The audit is also there to check the level of compliance, but also to assist where necessary, in order where accountable institutions need any assistance when it comes to what it is that they need to do extra to comply. And then secondly, go AML registration. Make sure that that is sorted 100%. Okay. It is advised for the money laundering officer, whether you want to call it the compliance officer, money laundering officer, whoever is assigned within the organization, it is advised that that person logs in on a regular basis to make sure that those login details work perfectly. Why? Because there's a lot of communication that gets sent via that specific portal. Okay. That's number one. Secondly, reporting happens there. Okay? And reporting is a big part of this piece of legislation. Okay? So make sure that you log in there, that you register to get the information from the FIC, especially if there's updates on the TCF list of people. Make sure that that works perfectly. Okay. Might be that the organization only has a money laundering officer on the registration portal, but it might also then be that the actual organization, due to the size, also have people registered that assist with reporting. Make sure that those things are in place and work. The risk management and compliance program process. Ladies and gentlemen, that alone is something that we will discuss in future. That document is your FIC Bible. Everything that you do is documented in that. All the processes, everything you do as per legislation required, needs to be in that RMCP. And again, this year we had to make some changes. We will have to go back this year to make some changes as well. Because, as I say, because of the 8th of August, everything that you do needs to be documented there. Yes, legislation under Section 42 requires certain things to be in the RMCP, okay? Whether it applies to you or not, you still need to make mention of it, and then, of course, explain why it is not applicable to you, okay? I get a lot of times, I get somebody reaching out to me saying, can you please review my RMCP? I need to make sure it's up to date. and then I get a 10-page document. Ladies and gentlemen, this is not a 10-page document anymore. This is all your processes. Okay. So you got to make sure that that RMCP complies 100%, and it clearly sets out what your processes is when it comes to mitigating risks, customer due diligence, transactional due diligence, ongoing due diligence, just mentioning some of the, highlighting some of the stuff in there, proliferation financing, freezing of assets. How does that work? Can I freeze assets? If I cannot freeze assets, what is the process that I'm going to follow? There's a lot of things that go into that specific document as well. The other thing is, as you know, last year it was requested under Directive 6 and Directive 7 for accountable institutions to go and complete those directives on the FIC website. Unfortunately, about 2 weeks ago, the FIC released, some statements relating to industries that have not completed the directive, specifically focusing on the percentages. Looking at legal practitioners, only 60% of legal practitioners have completed that directive. Estate agents were roughly about 66%. Trust services, 74%. Company services providers, 76%. And then casinos, actually 100%. I encourage you to please go and complete that directive, because that is one of the things that is holding us back of getting off the grey list. But here's the thing. Do not just go and complete that directive because Cedric this morning said you must go and do it. You can only go and complete that directive if you have a solid RMCP in place. You've looked at your processes, you know what is expected of you, and that you've tried your best to become FIC compliant. Don't just complete it because it needs to be completed, because you are answering information there, keeping in mind that the FIC already thinks that it's in place. And if it's not in place, it's not an ethical way of doing it. So don't do it the other way around. Start from the beginning, make sure that you put what's in place, and then go and complete the directive. Please, if you feel that you've missed the deadline, you've still go and complete it. It is open. It is a big thing. Okay. Then, of course, reporting. How does reporting lines work? Who reports? What type of reporting needs to take place? Turnaround times. All of these type of things. Sorry, I beg your pardon. And then also, lastly, sorry about that. One needs to also, sorry, I beg your pardon, the screen is now skipping by itself, clicking. But these are the things that you need to be aware of when it comes to what it is that being prepared. Training, lastly. There's a misconception around training. Some organizations, some accountable institutions think that just giving staff training on FIC is enough. Yes, it is a requirement that there's ongoing training that takes place, depending on the risk relating to the accountable institution. But what some accountable institutions miss is the training on the RMCP for staff. Okay. That will be checked. So when they ask you for your training registers relating to FIC, you can present them with training where they've received FIC training, whether it's annually, biannually, quarterly, whatever it is that you decide, whatever is documented in your RMCP, but also the training on the risk management compliance program and how that is done. And they prefer that there's an assessment. And that's the decision of the accountable institution, how they want that assessment to look. Of course, it needs to be thorough. That there's an assessment, checking the understanding of the RMCP and what this is about. So please don't just think it's just FIC training. There needs to be training done on the risk management compliance program as well. Okay. What does the notice of the inspection contain? So information on the inspector, will be on there. There's a bunch of stuff there. There's even a photo there of that individual coming and having a look at, you know, what it is that he's coming to do. So you've got your letter coming. Then, of course, we have information requested before the inspection. So the appointment letter of the CO, so they will ask for certain things. Okay, so it's the money laundering officer. Please send me the letter where you've actually appointed this individual. Okay, not just walking in and sticking a finger in somebody's face saying you're the money laundering officer. There needs to be an official process and signing off and a decision on who this individual is going to be. Registration of proof, send your RMCP, and possibly a list of suspicious transactions if you did have any of those reporting obligations that needed to happen. And then, of course, information during the inspection, bank statements, and client files. Client files, very important, because when it comes to client files, there's a lot of things that they check. So in your RMCP, hopefully, you have a risk matrix where you've identified certain risk areas based on your risk on a specific client, whether it's low, medium, or high. You will gather documentation, which is part of your customer due diligence process. Okay. So in that file, the inspector or analyst is going to have a look at your RMCP, have a look at what your risk rating is, whatever that might be. They're going to look at your due diligence process relating to the documentation that you needed to get, and is that on file? Okay. There's a lot of other things that they're going to check. Source of wealth, source of income, is that there? Who onboarded the client? There's a lot of other stuff that's going to be in that file. Okay. They're really going to go through that file. You can go and read up on legislation. Legislation requires you to have certain things on file. That makes sense because, first of all, you need to comply. And secondly, if there is an investigation maybe around a specific individual, that you can present that to them as well if they pick up something from a reporting perspective. Okay. So files should be should be thorough. Okay. You can't miss any documents. If you are missing one document, you are going to fail that file sample, all right, which you don't want. Okay. Also, dealing beneficial ownership, relating to whether you deal with legal entities, partnerships, all of those type of things. Make sure that all of that information is on file as well. And as I've mentioned, on the 8th of August, the FIC have released their PCC 59, where they changed the threshold from beneficial ownership from 25% to 5%. So please be aware of that as well, which means that, again, we need to go and revisit our RMCP, adapt it, change our staff, implement it, and then follow the procedures. Okay? And as I've mentioned, as long as we are on the list, we're going to keep on seeing these changes coming forth. Also, it might be that the client has been with you some time, and on the file sample, your RMCP talks about ongoing due diligence and transactional due diligence. So if you've transacted, again, with that client since onboarding, is your transactional due diligence there? Have you screened the client again? Your ongoing due diligence, which is also a risk-based approach. So my risk-based approach, for an example, is that every second year, I revisit my low-risk clients in order to determine if their situation is still the same. Is my ongoing due diligence documents on file, and can whether it's the analyst or the inspector see that? So files needs to be thorough, and it needs to be very important. It needs to be in good condition, okay, so that you can actually make sense. So if I'm asking for a copy of an ID, if I'm identify and verify, those are specific words that has specific meanings. If I see a copy, I'll make sure that I am able to actually identify and verify who that individual is. So the state of the documents are also very important. Right, let's look at during the inspection. So what happens there during the actual inspection? Background of the information of the accountable institution. So you tend to find that the individual doing the actual audit talks about gathering information about what the organization is, what it is that you are about, what is it that you do, what are the services that you provide, where do you provide services to, what type of customer base do you have, where are your clients situated. And the reason for them is to try and get an understanding of that, of course, what's going on in your business, that you've applied your mind, and based on your business, you have implemented some form of a risk-based approach relating to where my organization is vulnerable when it comes to money laundering or terrorist funding, proliferation financing, whatever the case might be. Okay, so it's to try and get an understanding of what's going on. Also, an organogram. So who governs this organization? How many staff do you have? Where do they fit in? Where do they fall in? How many staff onboards clients? How many are client-facing staff? These type of things. Then, of course, big focus on as I've mentioned before, the risk. How did the organization determine their risk matrix, their risk-based approach? Did they do some form of risk assessment? How does that look? What did you do? What are the factors that you've taken into account? And yes, ladies and gentlemen, I know that there's a lot of people out there that have templates going around that you can get for free. And I'm not saying that there's anything wrong with that. I'm just saying that in this specific scenario, when it comes to processes, policies, and a risk management compliance program, just taking a template and doing small changes is not going to be enough. This requires in-depth discussions, looking at your business holistically and where possibly somebody can do something, and then putting the necessary in place in order to try and prevent as far as possible that somebody uses your organization. And then, of course, the general behavior of the accountable institutions employees. Are they comfortable with FIC? Do they know what it is that they are supposed to do? Do they know it's part of their day-to-day activities? Are they alert when it comes to money laundering and terrorist funding? And I'm not talking about walking around and being suspicious of everybody, but are they educated enough that if something, that gut feeling comes in, that something doesn't sound right, that they know exactly what it is that they need to do, to reach out to the relevant people in order to start the actual process. Let's look at what are the duties of the FIC compliance officer. Now, very long time ago, as I've mentioned to you before, there was not always a lot of thought put in to who this individual was, due to legislation not being so intense. The person that you decide to be your FIC compliance officer, that individual needs to be a suitable individual. They want to see that, and they'll talk about that in the inspection as well. Why did you choose that individual? What is the reasoning behind it? If it's the head of the organization, it makes things sometimes a little bit more easier. If it's not, they would want to know, does that person, because that specific person that you are choosing needs to have sight of all operations within your organization, needs to have thorough knowledge of how day-to-day activities work, have insight where there is decisions being made that impacts the business, that might place the business in a position where it's vulnerable and it opens itself up to money laundering or terrorist funding. Okay. This person needs to have a seniority position within the organization. It can't just be anyone. Okay. There is responsibilities, and we're not going to go into that now in detail. For an example, we can just quickly mention I mean, that person needs to make sure that there's an RMCP in place, that it gets maintained, that in the that the RMCP is signed off and approved by the board of directors, which is very important. Inside that document, there needs to be a process where they verify client risk ratings. There's a matrix that, of course, person does all the reporting, whether it's cash thresholds, suspicious activity or transactions, terrorist property. And of course, that person is also the individual that liaises with as the representative from the organization towards the FIC. So the inspector is going to want to see that letter, know that paid person is in that letter. It needs to state the date when that person was appointed. Also, that person needs to be able to evidence and show that they ensured that training was done on FIC and also on the actual RMCP. And then, of course, whatever you decide when your RMCP gets reviewed, that person also needs to make sure that the review actually takes place. Now, your RMCP might say that we will review annually, but under certain circumstances, when there's changes in legislation, changes in the business, changes in procedures, adding more services, adding more products, then, of course, we need to review the RMCP as well. Okay, so this person does have duties. That person, of course, is definitely part of the actual audit. And yes, so please make sure that whoever it is has enough knowledge. And if it's not the head of the organization and you're choosing somebody else, please give this person the necessary support in order to perform their duties, because they need to understand that these duties need to be taken very, very seriously. Okay. Why is the customer due diligence of clients important? In the actual inspection, they are going to look at what your due diligence process is, which needs to be documented in your RMCP. Okay. Clearly state what that process is. Okay. Types of clients, and then, of course, risk factors. Okay. Due diligence, if you're dealing with clients, you need to know who you are doing business with at the end of the day. I get a lot of the times I know everybody that I do business with. Cedric, it's friends that refer friends that refer friends. I don't understand why. I get what you're saying. It's not because you know this person that you are exempt from risk rating this individual and performing your customer due diligence process. That needs to be done on every client. You cannot skip a client just because, even if it's your best friend, you need to follow your customer due diligence process. They will check that. They want to see it. And they will measure it when they do file sampling, as I've mentioned to you before. Risk factors, how did you go about choosing your risk factors? What things did you take into consideration? And then, of course, some of the terminology. In the RMCP, we throw around a lot of terminology, CDD, terrorist properties, different types of terminology. Does the staff understand what that terminology is? Should I rather talk about a customer due diligence process, or can I refer to the terminology around that? Okay. And as I've mentioned to you before, beneficial ownership. Beneficial ownership, you are not exempt from onboarding individuals that are part of beneficial ownership. And as I've just mentioned, please go and read BCC 59 and the suggestions that they're making there relating to 25 dropping down to 5%. Okay, beneficial ownership, it might even be that getting an audit, that the theme, whether from the supervisory body or from the actual regulator itself, FIC, that they only purely focus on the onboarding of beneficial ownership. Okay. Also with that, screening, ladies and gentlemen. Screen your clients. And what does the legislation say? There's certain things that you need to do before you enter into a business relationship. Okay. Screen the clients before. Okay. Make no mistake, those dates get checked. Okay. And then, of course, there's screening as you go along as well. Keep records of the screening. I've had people say to me, I do screen. I promise you I screen, but I haven't kept record. Unfortunately, that will not suffice. Every time you screen, there needs to be a, whether you, whichever way you do it. Of course, if you use automated systems, makes your life a lot more easier from a record keeping perspective. If you're doing it manually, you're going to have to make sure that you keep a record of that as well. This is all part of the due diligence process around your clients, which is in your RMCP, which they will check, they will talk to you, and it needs to be detailed in your RMCP. Why is it important for the employees to partake in FIC training? Well, firstly, it is a, I beg your pardon, it is a requirement under Section 43. FIC Act states that training must be done. But above that, from a best business practice point of view, keeping people up to date, especially if there's changes. If you don't train them, they're not going to know. And if they don't know, things might just fall through the cracks. And that's what you don't want at the end of the day. Okay, so ongoing training does need to take place, not just as I've mentioned before on the actual RMCP, the Act itself, but also on the RMCP. So in detail, have training around the RMCP, because this is where the interviewing comes in. If you have an analyst or an inspector walking around asking questions, who is the money laundering officer? What are the time frames when it comes to reporting a cash threshold? When should you report a suspicious transaction? What are your reporting lines? What do you deem to be suspicious? Have you been provided with some guidance on what can possibly be suspicious? Okay. How often do you get training? What type of training do you use? They want to get a good idea that you've made this part of your day-to-day activities, and it forms an intricate part of your business. What are all the different things the supervisory body or FIC will check when they do file sampling? We've spoken about that. What documents is included? And of course, as I've mentioned, the condition of the documents. The conditions of the documents really needs to be in such a way that they can clearly see. So very important to do that. So how will it work when it comes to checking these type of or doing file sampling? Different ways of doing it. They might ask let's say something like a new business register, and they might choose files from there. Or they might say, just, give me some files. I also can't say to you, will they check 5 files? Will they check 40 files? Will they check 50 files? That, of course, is up to them. I do, however, see a trend, especially in the last year and a half to 2 years, that they do a lot more file sampling that they've done before, even if they do a desktop audit. Okay? Please make sure your files are correct. And then, of course, with that, what is also very important is the record keeping around that. Where do you keep the records? Is it safe? Do you make use of a third-party record keeping? If you make use of third-party record keeping, ladies and gentlemen, you know that you need to inform the FIC of that as well, because that will also come up, because that needs to be mentioned in your RMCP. Okay. Then just a little bit of a reminder, because this, as I say, needs to be in the RMCP as well, something that they will check. When should I report? What is cash? Some of the things that they can ask. So we know what is cash? Cash is coins, paper, traveler's checks. People need to know that. What is the threshold? 49, 999. How many days? 2 days. Okay. People need to know this. The reason why is that if you have a money laundering officer that needs to report and there's a cash threshold, that individual's got 2 days to do it. Don't wait 2 days. There's a process that actually needs to be followed on that system. So give enough time. Okay. What is suspicious and unusual transactions? Ladies and gentlemen, please note, under suspicious, there's 2 things. it's either going to be a suspicious activity or it's going to be a suspicious transaction. Please don't get confused, and make sure that you know that there's two things there. Okay, it's unusual or it's the actual transaction that can take place. Okay, and how does that process look? But because that needs to be done timeously. We all know that suspicious, whether it's a transaction or activity, has 15 days. And then, of course, when it comes to terrorist property, 5 days. It's always been part of regulation when they spoke about freezing of assets. Some of you, as I've mentioned before, might have the ability to freeze an asset. Some of you don't, due to the nature of your business. However, you can, whether it's reaching out to a bank or a product provider, bringing this under their attention that these assets need to be frozen immediately, as this person has just been, we've screened them again, they're popping up on the list. We need to step in immediately, whatever the case might be. If you do so, you need to do so within 24 hours. And of course, there's a reporting obligation on that as well, which needs to happen within 5 days. So it's important to note that as and when these things change, legislation change, that one stays up to date with it as well. What to expect once the visit has been completed. Okay, so they've came in, they've spent there, whether it's a day, whether it's 2 days, whether it's 3 days, all depends on the size and the complexity of the actual organization. This is what one can expect afterwards. So you are going to get a letter back from them, very much detailed report, okay, of all their findings, of everything that they've checked, okay. That can go both ways. You might get a very good report, well done. Or you might get a report which is not that great due to not being fully compliant with all the actual requirements. In that, there will then be remedial actions that needs to be addressed. Please address those remedial actions timeously, as you will be given certain times to fix this. Attend to it immediately. If you need to reach out to people to assist and you don't feel comfortable doing it on your own, please do so. However, it will clearly state where the issues lie, whether it's in a process, whether it's screening, whether it's the RMCP, whether it's training, whatever it is. And then, of course, depending on the severity of non-compliance, administrative sanctions might be imposed on the actual accountable institution. And that, of course, is something that one desperately wants to avoid within your organization. It's, as I say, it's not just about getting administrative sanction, ladies and gentlemen. We all know that there's something called reputational damage. And we want to protect our organization at all costs when it comes to these type of things. Different types of inspection reports. So as you can see, the remediation of non-compliance contains findings, remedial actions, address them timeously, immediately, and demonstrate full compliance. Not just changing a couple of sentences. Go and look at the process, review it. If it's training that is insufficient, put the necessary in place. Do it the right way. Don't find a quick and easy way fixing it. And again, if you're not going to comply, unfortunately, administrative sanctions will be imposed. This moment in time, it's always been serious. However, now, these days, it has even become more serious. Okay, people have had a lot of time given by the regulator to comply with relevant legislations. And unfortunately, we have certain organizations that fall under accountable institutions, not even new ones, I'm talking about older ones, that have not embraced this legislation and has not done what is required. And if you have not done, because please remember, when an audit happens, and this is something that I want to highlight, yes, they're going to look at your RMCP because it had to change. They know it needed to change. Okay. They want you to keep your old RMCP so that they can see that you've complied with legislation from the beginning. Version 1, version 2, version 3, version 4. Keep your old RMCPs. Don't destroy them. It's evidence that you've complied in good faith with the actual legislation. What are some of the common inspection findings that we pick up? From a masthead perspective, what we see is issues that pop up when it comes to remedial actions or non-compliance. Believe it or not, the registration was the center under Section 43B. One would think that that's probably one of the easiest and the first things that you do. Unfortunately, there's some people that still have not registered at the center. If you have not done so, I encourage to do so immediately. Section 21, identification and verification of clients, very vague. What do you do? Not much effort being put into it. Basic stuff. And then, of course, if you're not doing it thoroughly, if you're not doing it in such a way where you are protecting the business and taking all of the things into account when it comes to identifying and verifying, then there's a lack of process, and you're opening up your business vulnerability for money laundering. The screening, where people screen, how they screen, how often they screen, when do they screen, as I've mentioned, most importantly. That's some of the findings that people do not do that, and that's something which is extremely important, because, ladies and gentlemen, please remember, you are not allowed to enter into that business relationship if you've not screened that individual. Because if that person is perhaps on the list, you're not allowed to enter into a business relationship with that individual. It's one of the requirements under the legislation. Cash threshold reporting, a little bit of a misconception there. Either people don't do it or they don't do it in time. Please note, if somebody walks into your organization with the actual cash threshold amount, it's rounded off 50,000 Rand, you need to, of course, report. But if a customer or a client pays cash into your account, not an EFT, cash, if they pay cash into your account, you also need to report within the time frame. It's not just if they walk into your office, it's if they're paying into your bank as well. And find that some people, I don't know if they misunderstood a little bit, or if they weren't 100% sure, but it goes both ways. So please do remember that. Then the duty to file suspicious or unusual transaction reports. Either people feel that whatever the reason is, but that they don't do certain reporting, and being in mind that if there's an analyst and an inspector going through a file, and they're looking at all the onboarding documents, and they find something that doesn't make sense, it's maybe around source of wealth or source of income, they might, reach out to you and say, but why didn't you report here? Something doesn't look right. And if you don't report, you're opening yourself up to positions where this specific individual might have dealt with other accountable institutions, which deemed him or that specific transaction or activity as suspicious. Now they're moving to you. You're not doing it. Why? What is your reason? So then you're going to have to explain to them, and whether it's based on mitigation of risk or the way you approached it, whatever it might be. But yeah, that's also one of the findings. And then training. Training is not done properly. We're not using proper resources to do the training. And of course, training is not done on the RMCP. And then unfortunately, the RMCP not being compliant with what regulation requires. Okay. As I've mentioned before, yes, there is people there, and thanks for that wants to help and gives guidance and gives templates, and it's for free. But you're going to still have to go and sit and spend a lot of hours to personalize that document and make sure that it is fully compliant. There's a lot of aspects and a lot of moving mechanisms, as I say, when it comes to FIC, but it's all centered around the risk management compliance program, that document that needs to be in place. Okay, so those are some of the common findings, and that's in the feedback that the accountable institution gets, and then they provide us with the feedback when they reach out to us and say, we have some remedial actions. Can you please assist us in addressing these things as we need to get back to FIC? When can an administrative sanction be posed on an accountable institution? Let's look at criminal sanctions. The maximum penalty for these offenses is 15 years or a fine not exceeding 100 million. Certain lesser offenses carry penalties of a maximum sentence of 5 years or a fine not exceeding 10 million. Remember, that's criminal sanctions. Please don't get confused. Administrative sanction, caution not to repeat conduct, a reprimand, a directive to take remedial actions, to make specific arrangements, the restriction or suspension of certain specified business activities as instructed by the supervisory body or the legislator itself, the FIC itself. If those are not addressed or not in place, financial penalty not exceeding 10 million in respect of a natural person and 50 million when it comes to a legal person. So as you can see, if one does not comply, the consequences can possibly be severe. Of course, after having an audit and you disagree and you don't feel comfortable, there is a process and steps that you can follow. First of all, you go to the FIC Act Appeal Board, where you can, present your case. Please, you must lodge that within 30 days, strict 30 days. There's a fee that you need to pay. That fee is 10,000 Rand. Of course, legal representation is allowed. And depending on what the outcome is, decision on further appeal to the High Court. So there is a process that you can follow where you can, get in or reach into a discussion with them if you don't agree with the actual findings. So ladies and gentlemen, very high level in a nutshell, looking at a holistic view when it comes to a audit by the supervisory body or the FIC, these are the things that they're going to check. They're going to be very thorough. They're going to make sure that they don't miss anything. They're going to ask a lot of questions. Thank you for taking time listening to me. It is much appreciated. I wish you all the best of luck. Please do reach out if you need any assistance, and enjoy the weekend. Thank you very much.
Thank you so much, Cedric. As always, a lot to consume by looking at the chat and even the questions, quite a lot of questions that have been posed. Up next is, of course, Vinette, taking us through the solutions that LexisNexis provide in keeping you compliant, and also to, I won't say complement, to also strengthen your risk-based approach within the organization. So over to you, Annette, whereafter we will be going over to the question and answer session. Thanks, Vinette.
Thank you, Melinda, and thank you, Cedric. Good morning from my side as well. So I just want to quickly share my screen with you. Okay, so like Melinda said, we at LexisNexis are here to assist you with solutions to be prepared and to be prepared so that when FIC, and to be compliant, so that when FIC would come and knock on your door, you would be compliant and you would be ready for them. So here at Lexis, we do have a suite of solutions that we can assist you. Number one is the Lexis KYC. So Lexis KYC specifically, and I just quickly want to echo what Cedric also said, this shouldn't be a burden. So all of these solutions are here to assist you, to make you compliant. So where Lexis KYC fits in, that is specifically focusing on your customer. When you are doing the FICA, when you're getting the FICA, it would be where we would check and verify these documents against reputable sources, specifically focusing on the IDs, documents, the identity, the contact details that they've given you. and then the world compliance check that we do. So, and then also there's the Lexis Ref Check. All of these products are online with Lexis Ref Check, which I'll do a showcase now, is about the Directive 8, which we haven't touched on today, but also it is screening your employees and making sure that that all of your employees are also compliant and that they are fit and proper to work at your company and at the firm. So just quickly, like I said, it's an online solution, so there's no installations required. So we will put up a poll now where you can advise us if we can contact you to set you up with this. There's no registration fee or subscription monthly fees. You only pay per verification that you do. So let's just quickly look at the Lexis KYC. That is now we are looking at the ID, the address, and the world compliance check. So we basically plug in with data sources, that is home affairs. We plug in with credit bureaus to verify the contact details of the customer or the client that you are dealing with. And then obviously the world compliance check, where we would verify against the TFS list to see if this person is linked to the government, the PIPs and the PEPs. KYC also speaks to the regulatory, big word there, compliance. So specifically where there's all the regulations with regards to your anti-money laundering, all of those regulations, KYC complies with that and making it easier for you to specifically comply with that. Then we've got Lexis KYC is also fully integrated. We've got the IP that we can log, that we can integrate into your solutions should you want to do that. And also for our customers that's attending to property transaction, we've got the Lexis Convey program where you capture the information once and all of that information will then pull through to the Lexis KYC online solution. Very super user-friendly interface. So, and we at Lexis are also there to assist you and guide you, also with the enhanced due diligence, with specifically, like I said, with regards to the world compliance checks that we do. It's a global check that we do. It's not just in the South African borders, but a global check, a deep dive on to see who and where your customer is with regards to being compliant. And then also, it doesn't matter if it's a small firm or a big firm, Lexis KYC can look at your, can definitely look at and assist you being compliant and specifically assist you having everything on paper. Because like Cedric said, when FIC would walk in and you will have the proof. So with Lexis KYC, you will be able to do, once you've done your verifications, you will be able to print a certificate to show that you've done your due diligence. Then just quickly looking at Lexis Ref Check, also an online product of ours where you can specifically, and you will find this very interesting, we can do the criminal checks for you specifically to see if your employees are fit and proper. This the absolutely wonderful growing check with a social media check to see that your customer is, and that your employees are fit and proper to work at your office and to deal with the specific work that they deal with. And then also having the online consent form that you can do that the customer or your employees can sign, and then you can keep on file specifically with Lexis Ref Check. So all of these are the information that you will have will be confidential. When you do these checks, it will be for your company and for your eyes only in the company. And the other thing that we can assist you with when you sign up, and let's say, for instance, you've got about 700 customers that you would like to screen at one time, and it looks like a whole mountain in front of you, we can assist you with batch processing. So you can give us all the IDs and all the details. We will provide you with with how we will do that, and then we can assist you to do a once-off batch to upload these customers into the system. So thank you so much. Please, you will see the poll on the screen now. Please reach out to us. We are ready for you to contact us and to sign you up and to guide and assist you. Thank you so much. Thank you, Melinda.
Thank you, Vinette. I think, Cedric, if we can go over to the Q&A session, we received quite a lot of questions. I see that we have about 12 minutes. I quickly want to go to the start of the session. There's a question there. I have a company that owns several properties with a growing portfolio. The company is not an estate agent. Am I required to comply with FIC? The company is not managing properties on behalf of third parties and manages only properties it owns.
Yes. Okay. So let's start there. Being an estate agent, no. So therefore, no accountable institution. That's correct. You're not an estate agent. But when it comes to managing properties, whether it's done by a managing agent, I'm not sure. Whether it's done, one maybe needs to just, in order for me to give a answer that is 100% correct, maybe we can get a little bit, if this individual don't mind sending an email, just bringing some clarity. We would love to get back to them just to confirm it's not necessary. I don't want to put my head out now and say no, because it might be that it falls under a different type of item within the different, schedules within the pieces of legislation. So, but so far, not 100% sure. It doesn't sound like it, but let's just get, if we can make 100% sure, that'll be great.
Yes, Cedric, I agree with you. And also based on the FIC legislation, there is a responsibility on accountable institutions, but also a responsibility on non-accountable institutions to also abide by some of the regulations in the reporting, as well as the checking of your customers and the type of transaction. So I agree. Let's get some further details. If you don't mind sending that through to us, we will always assist you further. I think it's always good to have the full detail. Another question from Alan. On the 12th of June, we were subjected to an off-site inspection. We have had no feedback. Is this normal, or should we expect a response as to how compliant we are?
Yes, that is normal. Please don't be. Yeah, it is normal. As I've mentioned in the beginning, depending on the information that they want to put together, depending on how long it takes for them to work through stuff, it might be that they're taking a little bit more time. So waiting for a couple of months for the FIC to get back to you is not necessarily bad news or anything like that, but it is normal. Yes, it is, especially because of the vast amount of audits that they are currently doing.
Another question. What if we did not hand in our tax directive 6 before the 31st of May 2024? Now we have received a sanction. Can we make a recommendation? In the interim, I have sent the risk compliance return questionnaire. I think if I can jump at this.
You can.
I think the best next step in advising you on this would be give us the opportunity to meet up with you, have a robust conversation about how we can assist you, even with the remedial action in the meantime. I think you've shown some action in doing the risk compliance questionnaire that shows intent that you're wanting to be compliant, and that's always a good sign for FIC. But I would suggest that we further this conversation with Cedric to help you with the remedial action.
Yes, I agree.
They were also in question if an accountable institution's money laundering compliance often leaves a company. how does the accountable institution access Go AML? Because login details and passwords are not shared.
Yes, that's correct. Yes, that's correct. Just there, 100%, the money laundering officer, it's legislated, is not allowed to share his or her username or password. However, your RMCP needs to stipulate and set out that when there is a change, what will be the actual process that I am going to follow. So if you, as the money laundering officer, is going to resign, it's part of your duty to inform the FIC that you are going to resign and that there will be a different person appointed. So there'll be a new ID sent, there'll be a new letter sent to the FIC that appoints that individual, and that person will create his own username or password. In the unlikely event of somebody not just pitching up at work anymore, and you don't, and that person did not follow the process, and you couldn't do the necessary change, we've seen that before as well. You then need to reach out to the FIC, and they will give you relevant guidance in order what to do and how to go about fixing that. Because there's no other way that you'll be able to reset.
Sorry, Cedric. Then also we had quite a few questions about the training, the RMCP training, and there was even a terminology used, accredited training. Now, I know for a fact that there is no accredited training, and FIC is not very prescriptive on the type of training, or there's a specific course that you get accreditation for. But please just elaborate on what is the processes, the documentation, and the records that you need to have in place for what is the FIC training that they refer to.
Okay, right. Yeah, thanks for that. Because I say, as I've mentioned in the training, that sometimes slips our mind. Again, the FIC is not prescriptive in saying it needs to be done this way. The reason why it doesn't need to be accredited is because generally each and every RMCP will speak to the process of the organization, and processes might differ. So unfortunately, there can't be standard training. So there's, from a practical stance, people do it in different ways. Some people go and take the RMCP. They highlight what they think is important for staff to know, specifically from a procedural perspective. You know, reporting who's the money laundering officer, what does due diligence mean, what does risk rating mean, and they build some form of presentation. Training gets done internally, whether it's by the money laundering officer or somebody, and then they get a couple of questions. Now, whether that's 10 or 15 or 20 questions, but there needs to be some form of assessment to determine the understanding of the content that you shared with the you know, with your staff. It might also be that people send out the RMCP to somebody. They tell them to read through it, you know, make sure you understand it, and then send them an assessment saying complete the assessment, send it back to us. They put a pass rate against it. No, the FIC doesn't say you must get 100 or 90 or 70%. Again, it's up to the organization where they feel comfortable related to the level of understanding. So really, an organization can apply their mind in doing that in different ways. But it is imperative that training does get done, and that there is some form of assessment. And then you need to evidence the training material that was used to whether it's the inspector or the analyst. So here's the material that we used. This is our training register, and this is how our assessment looked that we gave to our staff.
Cedric, we've got 3 minutes left. We had quite a lot of questions still unanswered. I think the steps going forward is that we will take down the answers. We will prepare a document and also share it with all the delegates who attended. Obviously, what we'll do is we'll just create a frequently or asked questionnaire document.
Yes.
I think it's relevant. We unfortunately did not have the time to get to all the questions. And I want to thank all the delegates for participating in posing these questions. Very informative, and also to show you the due respect on giving you the answers on this. I think it is important that we we give it the attention that it deserves. So thank you very much for that. Thank you for participating in the poll. Our next webinar, of course, this is a part of a series, as you all know. There is directives that will follow as part of the September 2024 conference of the Financial Action Task Force report cycle. We will definitely look into that to share some of the insights for you to be compliant. And we will also be looking at your RMCP, what changed and what do I need to update to stay compliant and committed to combating terrorist financing and AML, as well as peripheral financing for weapons of mass destruction. Thank you again. Have a wonderful weekend. Lexis value your insights, and hope to see you all in our next webinar. Thanks, everyone.